There are currently over 560 active international legal disputes happening right now, and in most of them, the losing party simply refuses to comply. No arrest. No seizure of assets. No jail time. Just a country saying no, and the world moving on. So if international law has no real enforcement mechanism, why does it exist at all? That question is more complicated than it sounds, and the answer will genuinely change how you see every conflict, sanction, and treaty on the news. In the next 10 minutes, you are going to discover how international law is actually structured, who writes the rules, who enforces them, and most importantly, who gets to ignore them. You will learn about the hidden machinery that makes countries comply even without a global police force, and we will get to the most counterintuitive insight in this entire field, the one thing legal scholars spend entire careers debating, which is whether international law is actually law at all. To understand international law today, you have to start in 1648. The Peace of Westphalia ended 30 years of devastating religious war across Europe. But more importantly, it established a concept that still governs global relations today: state sovereignty. The idea was revolutionary. Every nation-state is supreme within its own borders, and no outside power has the right to interfere in its internal affairs. For centuries, this principle held firm. Countries could do whatever they wanted inside their own territory, and international agreements only applied when nations voluntarily chose to sign them. The first real cracks in that system appeared after World War I. The League of Nations was created in 1920 as humanity's first attempt at a permanent international legal body. It failed spectacularly. The United States never joined. Major powers ignored rulings they disliked. And when the League condemned Japan's invasion of Manchuria in 1931, Japan simply resigned from the organization and continued the invasion. The lesson seemed to be that international law was powerless. But that is not actually what history shows us. What the 20th century actually demonstrated is that international law works best when it aligns with the self-interest of powerful states. After World War II, the Allied powers created the United Nations, the International Monetary Fund, the World Bank, and eventually the World Trade Organization. These institutions were not neutral. They were designed largely by the United States and Western Europe to reflect their values and protect their economic interests. And that is exactly why they worked, because the most powerful players had every reason to maintain the system they built. The United Nations Charter is the closest thing the world has to a constitution for international relations. It prohibits the use of force against another state except in self-defense or with Security Council authorization. It establishes the principle of sovereign equality, meaning technically, Liechtenstein has the same legal standing as the United States. But here is what nobody talks about. The Security Council has 5 permanent members: the United States, Russia, China, the United Kingdom, and France, and any one of them can veto any resolution. That means the entire enforcement mechanism of the United Nations can be paralyzed by a single country protecting its own interests. Russia's invasion of Ukraine is a perfect recent example. The Security Council tried to pass resolutions condemning the invasion. Russia vetoed every single one. So how does international law actually get enforced? The answer is through a combination of 4 mechanisms that most people never think about. First, reciprocity. Countries follow international law because they want other countries to follow it too. If the United States honors an extradition treaty with France, it is because it expects France to honor the same treaty when roles are reversed. Break the rule once, and you lose the benefit forever. Second, reputation. A country that consistently violates international agreements becomes a diplomatic pariah. Other nations refuse to sign treaties with it, cut off trade relationships, and exclude it from international forums. North Korea has been so isolated by this dynamic that it has almost no functioning diplomatic relationships outside a handful of allies. Third, economic leverage. Sanctions are arguably the most powerful enforcement tool in the modern international legal system. When the United States and European Union imposed sanctions on Russia following the annexation of Crimea in 2014, the Russian economy contracted by nearly 4% in a single year. Fourth, international courts. These include the International Court of Justice, the International Criminal Court, and dozens of specialized tribunals covering trade, investment, and human rights. The International Court of Justice, based in The Hague, settles disputes between states. It has handled cases involving genocide, maritime boundaries, nuclear weapons, and diplomatic immunity. But here is the critical limitation. The ICJ can only hear a case if both countries agree to its jurisdiction. And it has no independent enforcement power. When Nicaragua won a landmark case against the United States in 1986 over the CIA support for Contra rebels, a case where the court found the United States had violated international law, the United States simply withdrew its acceptance of ICJ jurisdiction and ignored the ruling. Completely. Legally, nothing happened. The International Criminal Court is a different animal. Created by the Rome Statute in 2002, it prosecutes individuals, not states, for war crimes, crimes against humanity, and genocide. It currently has jurisdiction over 124 member countries. But the United States, Russia, China, and India have never ratified the Rome Statute. That means nearly half the world's population lives in countries that do not recognize the ICC's authority. In 2023, the ICC issued an arrest warrant for Russian President Vladimir Putin for the alleged unlawful deportation of Ukrainian children. Putin has not been arrested. He will not be arrested unless he sets foot in a country willing to detain him and hand him over, which is essentially never going to happen voluntarily. But here is what nobody talks about when it comes to international criminal law. The ICC has overwhelmingly prosecuted leaders from African nations. Of the dozens of individuals it has convicted or is currently trying, the vast majority are from sub-Saharan Africa. This has led the African Union to formally accuse the court of being a tool of Western neocolonialism. Several African countries have withdrawn or threatened to withdraw from the Rome Statute. The legitimacy of international law depends entirely on whether states perceive it as fair, and for many nations in the global south, it does not. International trade law is actually the area where international legal compliance is strongest. The World Trade Organization has a dispute resolution system that is remarkably functional by international standards. When countries win cases at the WTO, they are authorized to impose retaliatory tariffs on the losing country in proportion to the damage caused. This creates real economic consequences. Between 1995 and 2023, WTO members filed over 600 disputes. Roughly 90% were resolved either through rulings or negotiated settlements, without military confrontation. That is a remarkable compliance rate for any legal system, domestic or international. Customary international law adds another fascinating layer. Beyond written treaties, there is a body of unwritten rules that bind all states simply because nations have consistently behaved that way over time with a sense of legal obligation. Diplomatic immunity is the classic example. No treaty signed by every country on earth requires it. But virtually every nation in history has respected it, because the alternative, harming foreign diplomats, would destroy the entire system of international relations that every state depends on. When Iran held American diplomats hostage in 1979, the international condemnation was nearly universal, including from countries that were otherwise deeply hostile to the United States. The deepest philosophical debate in this field is whether international law deserves the label of law at all. The legal scholar John Austin argued in the 19th century that law requires a sovereign with the power to command and punish. By that definition, international law is not law, it is just a collection of political promises. But modern legal theorists like H.L.A. Hart responded that what makes something law is not the threat of force behind it, but its systematic acceptance and application within a community. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Eagle Brief for a brand new video every single day. We will see you in the next one.